You actually have a piece on another magazine ban being upheld and some of the implications of that.
Yeah, so we had a big ruling out of the First Circuit, the Boston-based Federal Appeals Court, essentially upholding Rhode Island's ban on magazines that hold more than 10 rounds. That's how they define their large capacity magazine ban. And it's, pretty in line with a lot of the quote unquote hardware ban cases. So things like quote unquote assault weapon bans and magazine bans. There's sort of been this coalescing of judges that uphold these laws around a particular reading of the Bruin test, where they say, sure, we'll grant you that there's no direct analog to the founding area of hardware bans, but Bruin instructs us that things like unprecedented societal concerns brought about by dramatic technological changes allow us to do a more nuanced approach to history, allows us to analogize more loosely over a broader period of time, or so they say. And so they tend to bring things like the Bowie knife bans that were fairly common in the country in the late 19th century, so the late 1800s. Even things like the National Firearms Act, when we cracked down on short-barreled rifles, sawed-off shotguns, machine guns, that sort of thing. And they say that
just demonstrates from the 1930s.
Right. Yeah. We're getting into the 20th century in a lot of these cases. But they say that demonstrates a tradition of basically governments responding to new innovations in weaponry that lead to some, murder or some organized crime in the case of the National Firearms Act. Yeah. And that demonstrates a tradition that allows you to then look at modern AR-15s or magazines and say that we can ban those as well. So certainly interesting. Obviously, gun rights people have a problem, I think, with that. You see a lot of criticism saying that that's, you're misreading Bruin, or you're making a mockery of Bruin by drawing on all these late non-founding area analogies, or you're interest balancing by other means.
But the bigger problem here, which you touched on a lot in your, it was sort of the core of your member piece, your analysis on this whole situation. Because you're right, like this has been the go-to justification for upholding a lot of these hardware bans, and it's become commonplace in these cases. And one of the issues is that these cases all take place in the same types of jurisdictions, right? The same circuits, and that's because they are the circuits that oversee the states that have these laws. There's not that many states that have these laws, and they're sort of geographically isolated from elsewhere. They're more liberal states, and they produce more liberal circuits because of how the federal court system works, right? I mean, there's the home state, people from the circuits get to nominate judges in a lot of cases. There's been a lot of senators from those states have more say in who gets appointed to those circuits, and so there's it's created this kind of geographical trap, I guess, for gun rights proponents, right? That's sort of
what they're sort of caught between a rock and a hard place, because this standard for upholding hardware bans has become almost so commonplace. And because, like you said, there's only about a dozen or so states with assault weapon bans / magazine bans where these challenges could even theoretically take place. You're sort of very limited in where these challenges can go, and they're going to all the same judges that all use the same standard. So it's almost like, they're going to lose every time. And we've seen that and reflected in many of these federal court rulings that hardware bans aren't being struck down in most cases. So they pretty much have to rely on the Supreme Court one of these days. We don't know when. We've covered the fact that so far they've shown hesitance to take up assault weapon ban cases. Until that happens, it seems like that trend's going to continue, where it's just going to be, this is the standard. We're going to go with this more nuanced approach, and hardware bans are allowed to stay. Right.
And of course, without circuit splits, because a lot of the circuits dealing with these things all seem to be fairly well in agreement on this justification that you're talking about, that makes it less likely for the court to take it up, or at least makes it a less urgent issue, especially with all the other things that are they're teed up to take, like these felon in possession bans, challenges to those. So I don't know. It's interesting. And I think it is, that is obviously not the only way this court can take up a case. It could decide to take up. And in Sullivan's case, especially if it finds that this justification is as bad as gun rights advocates say it is, right? The court can itself go in and take this case, which is kind of what Bruin was to some extent, right? they, a lot of Bruin is just complaining about the lower courts and how they have, how Google has decided to turn itself on. Lovely, but sorry about that. Yeah, so we'll see what the court does. They I think will be the ultimate. I mean, they always have the ultimate say, but it's whether they get involved or how fast they get involved, I think, is the bigger question. Bruin was a lot of complaining about the lower courts not doing what they wanted, but it didn't happen until 14 years after Heller was handed down.
Right.
So,
right.
That's another issue that the gun rights advocates complain about, and we'll see what the court does this time around.